Sorry about the delay there. Ready to get started. I think Mr. Musel is connecting.
Hello.
All right. Is Mr. Musel, are you able to hear me okay?
Yes, I am.
Okay, we'll go on the record in People versus Dustin Musel, file number 256829. The record should reflect that Mr. Musel is present today by video by prior approval of the court. If I could have counsel put your appearances on.
Thank you, Your Honor. For the record, this morning, we're going to People.
Thank you, Your Honor. Richard Trush, appearing on behalf of Mr. Musel.
Okay, this is set as a final status conference today and plea cutoff. We do have trial set to begin next Monday on the 28th. Mr. Trush, have you gone through any plea offers with your client?
I did, Your Honor. We've continued to negotiate with the prosecutor, and I do believe we have a resolution for the court whereby Mr. Musel would be admitting to the domestic violence third as a habitual second, the R&O as a habitual second. The remainder would be dismissed.
Okay, so the domestic violence third, would that be a
And
count four?
court judge and count two. Make it easier for the record.
Sure. Right, and as a, what's the DV third max penalty?
It's 5 years with the habitual second, 7.5.
Oh,
Right.
all right, thank you. Mr., and just for the record, I think you said this, Mr. Rolla, but that's a correct statement of the plea offer.
That's a plea offer that was extended by Ms. Brooker from our office, yes.
Okay, Mr. Musel, were you able to hear what your attorney said about the plea agreement in this case?
Yes, I have.
Have you had an adequate opportunity to talk to him about that?
Yes, I have, Your Honor.
Is that how you wanted to proceed today?
Yeah, yes, Your Honor.
Okay, can you raise your right hand, please? Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do. Yes.
Thank you. You can lower your hand. Mr. Musel, at the time that this incident occurred, were you on probation or parole anywhere?
I was on call-in probation to pay a fine. So it wasn't set up to go into the office. It was just to make sure I was paying my fine.
Okay, where was that out of?
In Gaylord, Otsego
Okay.
County.
Okay, are you aware of that, Mr. Truth?
Was that to the circuit court or the district court, Mr. Musel?
This district court.
And are you still on probation to them?
I never really was. I was just told to pay my fine. That's what I was doing.
Have you paid those fines up, or do you still owe that money to district court?
I still owe the money.
Okay. All right. I'm not sure if that means that you're currently on probation there, or if you're just on, some type of payment plan. So do you
Yeah.
report to like a probation agent in the district
No.
court?
No,
Okay.
I was on a payment plan. That's what was set up.
Okay, gotcha. All right. So in this case, you're going to be pleading guilty to one count of resisting or obstructing as a habitual second offense. That means that the maximum possible penalty that you could face for that charge would be up to 3.5 years. Do you understand that?
Yes, I do, Your Honor.
And then, as we were discussing here, the maximum possible penalty that you could face for domestic violence third offense as a second habitual offender is up to 7.5 years. Do you understand that?
I do, Your Honor.
With those maximum possible penalties in mind, what is your plea to each of those charges today?
I. It's. You know, I'm in a ministry now. And I've been doing so good and it, I just feel like I'm forced to lie, but I guess I'm, say I'm guilty.
Okay, well, you just took an oath to tell the truth.
Yeah,
So, if you're telling me after taking that oath that you're now going to deliberately lie, that's something that we can't really do here. So whatever we discuss from here on out, I need you to be clear that it needs to be the truth, okay?
okay. I am guilty for, RNO for not obeying an order. And I am guilty for pushing my, girlfriend. So I guess I would say that would be abuse.
Okay. All right, so I'm gonna go through your rights with you. Right now, you have the right to have, and one thing I should mention to Mr. Musel, because we're doing this remotely, if at any point you can't hear what I'm saying or you need me to repeat something, just raise your hand or let me know, and I'll make sure that I do that, because I want to make sure that you hear and understand everything that we're doing, okay?
I will do, Your Honor.
Okay, so I'm gonna go through your rights with you. You have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you, and the right to testify at a trial yourself if you want it. Do you understand that you have all of those rights?
I do, Your Honor.
And you understand that by pleading guilty under this plea agreement, that you would be giving up and waiving all of those rights and you would not have those anymore.
Yes, I do, Your Honor.
Okay. Also, you don't have an automatic right to appeal the plea that you're making here today. You can only do that by leave, and that means that you would have to ask the Court of Appeals to hear your case. If they said no, then that would be the end of that appeal. Do you understand that?
Yes, I do, Your Honor.
Has anybody threatened you with anything to get you to plead guilty?
No,
Has anybody promised you anything other than what we've talked about here on the record today?
I thought that the habitual was dropped completely, but other than that, no.
Okay. You understand that as part of this agreement, it's not dropped completely, right?
Yeah, now I do, yes.
Okay. Is it your own free choice to enter into this plea today?
It is, Your Honor.
And then I think you've already said this, but again, you've indicated that you're pleading guilty because you are guilty of the resisting or obstructing, correct?
Yes, I failed to follow an order but I did not use physical violence in any way.
Okay. All right. And then you said that you are guilty of the domestic violence for pushing that individual, and we're going to talk about that a little bit more in detail. Is that correct?
That is correct. I was defending myself. I should not have pushed her, so I did cause harm to her. Yes. Yeah.
All right. So the date that I have for this incident is back on January 11th. Is that correct?
That is correct, Your Honor.
Okay, and was that like in the nighttime, maybe around midnight of January 10th or January 11th?
It was in the evening. It was more like around 8, 9.
Okay. And at that time, were you here in Otsego County when this incident happened?
Yes, I was, Your Honor.
All right, and you mentioned your girlfriend. That's somebody that you had a dating relationship with, or some other type of domestic relationship. Is that correct?
We were engaged, and I was living with her.
Okay, and is that where you were living together? Is that where this incident happened?
Yes, it is, Your Honor.
Okay. So, Mr. Trush, I don't know the circumstances, obviously. Maybe you can flesh that out.
Sure. So on that date, did you and your girlfriend Tara have an argument?
Yes,
Did that argument turn physical?
yes,
And did that result in you pushing her?
yes, it did.
After that, did the police show up?
Yes, they did.
And you knew that who you were interacting with was the police on that date?
Yes,
When you interacted with the police, did you tell them that you were armed?
no, I actually said, if I have a gun, then shoot me, because I did not have a gun on me. And I suffer from major depression, and I just wanted to die, that night.
When you interacted with them, did they give you commands that they were placing you under arrest?
No, not at that time. I came out, and I willingly, and we walked to the patrol car, and then they had said we are investigating, and we went back to my residence for them to investigate. Then later they had told me I was going to jail.
So you had indicated that they had given you some commands you didn't comply with. What command did they give you that you didn't comply with?
Throw the gun out. If you have a gun, throw it out. And I wasn't in the right state of mind. I said, if I have a gun, shoot me. Just shoot me.
Okay,
But-
so when they told you to throw the gun out, did you keep your hand in your pocket?
I do believe so. I did. And then I confirmed with them that I didn't have a gun. I went with them. There was no physical violence at all. So I obeyed the order.
So you said that they told you to throw the gun out. Were they trying to get you to show them that you weren't armed?
I do believe so. And I was hesitant about that because I just, like I said, I was so depressed and from PTSD from them. They just wanted to not be living anymore. But I'm so glad for that night to happen, because now I'm here. I have a purpose. I know that God wants me to be here. So
When they told you to do that, you didn't do it when they told you to do it, correct?
no, yeah, you were correct.
I think that would supply the basis for the RML.
All right, is Mr. Trush, is there any dispute about Mr. Musel's prior record in terms of his domestic violence convictions that would make this a third, or is it habitual?
No, we would stipulate to the facts contained in the information.
Okay. All right, with that, Mr. Rolla, are the people satisfied with the factual basis?
Yes, Judge, specifically as to the RNO that the officers is now acknowledged by the defendant, told him to take his hand out of his pocket and he refused to do so. I think that was sufficient under the statute with the other information the court has. The only question people have is where he was actually at when they told him to take his hand out of his pocket. We had the start of the incident, not necessarily the end of the incident.
Yeah, Mr. Musel, this all occurred, including your interaction with police that occurred at the house that you were living at in Otsego County.
Yes, I was on our property. I ran across the lake, but I was just trying to find my fishing hole to jump in, but I didn't find it. But yes, I was there.
Okay.
With that clarification, are the people satisfied with sufficient factual basis to accept defendant's guilty pleas to count 2 as well as adding count 4?
Okay, Mr. Rolla, or I'm sorry, Mr. Trush, are you satisfied with the factual basis?
Yes, Your Honor.
Mr. Rolla, are the people aware of any threats, promises, or inducements other than what's been placed on the record?
No, Judge.
Mr. Trush,
Defense is satisfied.
Mr. Rolla, are the people satisfied that the court has complied with statute and court rule in the taking of this plea?
Yes, Your Honor.
Mr. Trush.
I'm satisfied.
Thank you. Mr. Musel, the court finds that your plea is knowing, voluntary, and accurate. The court is satisfied that there is a factual basis to support a finding that you are guilty of each of these charges. The court will accept your guilty plea. This matter will be set for a sentencing hearing. You'll be notified of the date and time of that hearing. It's going to be in about 30 days. So, Mr. Musel, are you still going to be at that facility where you're at?
I will be, Your Honor.
All right, Mr. Trush, does he have the ability to come here for sentencing, or do you know what the circumstances are?
I guess what I would indicate to the court, I think it's clear his preference would be to do it via Zoom. I suspect that we can arrange transportation if we need to.
I mean, do you know what the guidelines are here?
I do. The guidelines are going to be on a prison sanction.
Okay, so Mr. Musel, you're gonna need to be here in person for sentencing on that date. So Mr. Trush, it sounds like you can work with him to.
And I can work with the ministry to arrange whatever we need to do.
So your attorney's gonna help you with that. And between now and then, Mr. Musel, somebody from the probation department will be in touch with you for a pre-sentence report. So just make sure that you follow up with them when they contact you. And of course, just make sure you stay in touch with your attorney, okay?
I will do. Thank you, Your Honor.
All right, thank you. And then in light of the plea, the court will adjourn the trial dates currently scheduled. And that's all we have for today. Thank you, Mr. Musel. You're free to disconnect at this time.
Thank you.
Judge, can I get a PAC code for the added count?
Oh, you could just ask Mr. Rolla.
Okay.
Okay, is Ms. Working present? Yes, okay. We'll go on the record in People versus Working, file number 25-6854. The record should reflect Ms. Working present here in the courtroom today. If I could have counsel put your
records on and they're going back to people.
Thank you, Your Honor. Richard Trush on behalf of Ms. Worth.
This is the date and time set for sentencing in this matter. And Ms. Working, have you had a chance to go through the pre-sentence report and talk to your attorney about that? Okay. And Mr. Trush, are there any additions, deletions, or corrections to that report?
No, Your Honor.
Well, just to the scoring.
No, Your Honor.
Mr. Rolla, do the people have any additions, deletions, or corrections?
No additions, deletions, or corrections required.
Any challenges to the scoring?
No, Your Honor.
Anything on behalf of the people for allocation?
Briefly, Judge, just the second summary situation with the circumstances of the guidelines as I see it are 0-17. The defendant in this particular matter is indicated in the PSI and also the police reports indicated the defendant was originally hospitalized in a severe alcohol situation. Then after being supposedly medically cleared for that particular matter, was released. But then for reasons which only she may know, went down to the cafeteria of the hospital, was trying to smoke in the smoking zone. They tried to get her to leave. Eventually, the police were called. She got trespassed from the premises. Then she tried to get back in by getting behind the officers. This is her fourth alcohol/substance abuse related conviction, as referenced by her priors in her both history and report 6 and 8. There should be some jail time to resolve in regard to this. Not only is this a situation that was completely unnecessary, but then she goes and tries to cause a problem from people who are effectively trying to help her, and the officers were not trying to originally arrest her. They just wanted her to leave the premises. Thank you, Judge.
Thank you, Mr. Church.
So I do agree with some of what the prosecutor indicated here. Ms. Working has some history. Most of the history is older. I think 6 out of her 10 prior things are 10 years or more old. I disagree with the prosecutor. I think, frankly, the history belies more of an alcohol problem than what he indicated. He indicated a few priors, but frankly, I think there's more than that. If we look back through the history, entry 3 contains a disorderly person drunk. Entry 6 is a controlled substance offense. Entry 7 contains a count of operating while intoxicated, albeit ultimately she didn't plead to that, it contained that. Entry 8 contains an operating while intoxicated as well as an open intoxicants in a vehicle. Entry number 9 contains an open intoxicants in a vehicle. And then surprise, in this offense, I think it's very, very clear that alcohol was a driving factor. She was at the hospital and she was intoxicated. She made the poor decision to smoke a cigarette where she wasn't supposed to. I don't think you're supposed to anywhere in the hospital, frankly, but she made the decision to do that. That triggers the police to get involved. They tell her, get out of there. They don't want to arrest her. That's clear. They just want her to get out of the hospital because it's causing a disturbance. She's doing something she's not supposed to do there. She then makes the poor decision to go back to the hospital after they told her to get out of there. This isn't a violent offense. She didn't fight with the police. She frankly was told to get out of there, and candidly, as intoxicated people do, she didn't make a very good decision. She did what they told her to and left, and then thought she'd sneak back in. I disagree with the recommendation here. 0 to 11 months, as the guidelines are, there's a presumption against jailing. The history here is mostly misdemeanors with a single controlled substance offense, again, 10 years ago. At that time, she completed the drug court program and candidly appears to have addressed at least the drug problem. The alcohol problem seems to be persistent, and that shows up in the history since then. In that circumstance, with a nonviolent offense, to recommend a straight jail sentence doesn't seem appropriate to me. It would seem to me that the appropriate response here should be aimed at rehabilitation. History has shown that she's done well with rehabilitation. She successfully completed the drug court again about 10 years ago. At that time, she appeared to successfully have addressed that drug issue. I think that the appropriate reaction here is supervision. She's shown that she can do that successfully. It appears as though all of her history, or the vast majority of it, is influenced by drugs and alcohol, more recently alcohol than drugs. A straight jail sentence here seems like a recipe to not address the issue and continue to be back here retreading the same ground. I don't think upfront jail is necessary here in a nonviolent offense with her history. However, even if the court felt some upfront jail was appropriate, I still think that a probationary term and oversight is the right decision here. because I think it's shown to be successful, and given where she's at with her history, it would seem that she should be given that opportunity. Thank you.
Thank you. Ms. Working, anything that you wanted to say today?
Sorry, I'm kind of nervous, but just wanted to say that I was sorry to the community, the police officers that were involved. They were just trying to do their job. It made it more difficult. And the last few months, I have been making strides to like get my alcohol under wraps, and I've been doing counseling and like with AA and stuff, and I can get there, and I'm just trying to, I don't know, hopefully get that under wraps so that way I can, you know, be a productive member of society.
I did read through the report, so I'm familiar with what happened in the circumstance. And there's a lot of information in that report about you and your circumstances as well. So I read through all of that. I take all of that into consideration along with what you've had to say and what the lawyers had to say here today as well. And you know, there's a couple things that stick out to me about this incident itself. It sounds like, just based on your statement that I read, that you really don't remember, you know, what happened, and which tells me, you know, you drank enough to get into a blackout kind of state where you're no longer really making any voluntary decisions, conscious decisions. And the problem with that, obviously, is you're not able to stop yourself even when you're doing something that's completely inappropriate, like in this situation where, you know, I think even the smoking in the hospital, if you would have just left, the police probably never would have even been called in the first place. So you just kept compounding this by your behavior, which I don't think at that point you were really in control of, consciously anyway. And that creates a problem for everybody, because now you're not controlling what you're doing. So now everybody else has to kind of babysit you and keep you in line. And that's not really the police. It's not their job, certainly not the hospital staff's job. So it's concerning that you get yourself into that kind of condition where you can't make real decisions about what you should or shouldn't do, and that you put everybody else at risk because your behavior at that point is completely unpredictable. Nobody knows what you're going to do next. And so it puts the hospital in jeopardy, puts all the people there in jeopardy. You're taking time and resources away from people who need it, and then of course from law enforcement who could be responding to more important calls during this time, instead of trying to convince somebody who's so intoxicated they don't know what they're doing to stop smoking in a hospital and to stop going back into the hospital. In terms of, you know, your past history, I think it's notable you've had 5 past jail sentences. You've been on probation 5 times in the past, according to the report. And I think it's great that you did well while you were on probation. A lot of people don't. And I think that does say something about you, like when you're forced to, you're able to comply and able to do what you need to do. What's concerning to me is after 5 times, you still haven't made that transition from doing it because the court's making you do it, or your probation officer's making you do it, and doing it because that's what you're supposed to do. And I think Mr. Trush certainly may make some good points about how the court should proceed. I view it a little bit differently in that at some point you got to start doing this on your own. We can't just put you on probation for the rest of your life so that you behave in an appropriate way. At some point, after 5 times, you know, the purpose of probation, in my view, is to give somebody a chance who made a bad decision, got themselves into a bad spot, to have some supervision over them, to get them back on the right track, and to show them what they need to be doing. It's not like a way to just control somebody's behavior throughout their entire adult life. And I think that's where we're headed with you. After 5 times, if you haven't kind of got it figured out, more supervision is a temporary fix. So at some point, you've got to make the decision that you're going to change, that you're going to do things differently because that's what you want to do, not because that's what the court's making you do. And we're at that point now where I'm not willing to commit the resources of the court to continue doing the same thing over and over again without any change in really your behavior. So I do think a jail sentence is appropriate. For those reasons, because of your past opportunities to avoid jail, to correct your behavior through probation that haven't been successful. So at this point, I don't think probation is appropriate anymore. I do think jail is appropriate given your behavior here and your past history. The guidelines are 0 to 11. The court is going to impose a 6-month sentence. I am going to require that you only serve 90 days of that up front. After 90 days, if you're eligible for the work camp, I don't have an objection to you being released to do the work camp for the last 3 months. If you can find some treatment and get yourself into treatment, I don't have an objection to you being released after 90 days to go to treatment either, because I do think that would help. But again, I think we're at the point where if that's what you want to do, you need to do that on your own. So the sentence of the court is, again, 6 months in the Otsego County Jail. You do have credit for 2 days served. The court's going to order that you serve the first 30 days of that up front, or I'm sorry, 90 days of that up front. The court has no objection to your release to either the work camp or treatment after that 90 days. If you're not eligible for either of those, then you would need to serve that entire 6 months. The court is going to order a crime victims assessment of $130, court costs of $325, attorney fees of $350, and a $68 state cost. You do have the ability to seek an appeal of this sentence, and Mr. Trush, if you can have this working, acknowledge your seat for appellate rights. Mr. Trush, were you ready on Ms. Vanier's case?
Yes, here.
Ms. Vanier, if you can go up to the podium there, please. And we'll go on the record in People versus Alyssa Vaner, file number 256855. The record should reflect Ms. Vanier is present here in the courtroom today. If I could have counsel put your appearances on.
Thank you, Your Honor. Richard Trush on behalf of Ms. Vaner.
If I could have counsel approach real quick, please. Go on the record and People versus Jones. This is file number 246775. If I could have counsel put it here.
Claire Brown, on behalf of Ms. Jones.
Is she present?
She is not, Your Honor, if I could make a brief.
Okay, yes, please.
This case has a lot going on with it, not just this particular case, but Ms. Jones in general. I have not been in very good contact with her. As the court is aware, the background in this case, she did not appear at the last hearing, I believe, because or one of the hearings, she was in treatment. She picked up another charge, which is still pending in district court. At the last hearing in district court, she was going to be taken by her daughter and admitted into a psychiatric hospital. I just received a message from her actually this morning advising me that she is now living downstate, looking for work. She was unaware of this particular hearing. She was only aware of the next hearing, which is going to be on Thursday in district court, because it was the date and time was given to her at the previous hearing. She will not be here today in person. I did advise her to at least log on to Zoom. Whether or not Your Honor is going to allow that, it's going to be up to you. And I did advise her she could be given a failure to appear for not being here in person as well, but at least to try logging on to Zoom.
Okay, Mr. Plea, do you know if there's been any contact from your office with Ms. Jones?
Agent Davis indicated she's not heard from her.
Do you take any position about how the court should proceed in light of her non-appearance today?
We leave it to the discretion of the court, Your Honor.
Right, court's information as well. I was going to request an adjournment given the pending charge.
Right, I mean, she did, it looks like she did voluntarily appear for her arraignment back on May 19th. It was not a bench warrant, it was a show cause arraignment. So the court will set this for one additional hearing. If she fails to appear at that hearing, I'll ask Ms. Davis to enter a bench warrant for her arrest. I do want to note that she is not in the Zoom waiting room. Mr. Brown, and I understand why you would say that to her, but going forward, I've been instructing counsel to not present that as an option to their clients, because if they're supposed to be here in person, they need to be here in person. If they want to appear by Zoom, I frequently grant that if they're in treatment or something like that, with prior approval. But just not showing up and then logging in as a way to appear is not acceptable. So please don't instruct your clients anymore that they can try to log in, because I'm not going to allow it. So they need to have prior approval. Aside from that, we'll set this for another hearing in 30 days, as I've indicated. If Ms. Jones does not appear for that hearing, then we'll go to the bench warrant. Okay. Mr. Frag, is Mr. Fragel? Is Chad Moore present? You know, is Mr. Fragel your attorney?
I don't have an attorney.
You don't have an attorney, okay. Oh, I see, this is for probation issue. Okay, Mr. Moore, if you want to come up to the podium, please. Mr. Brown, I'm just going to ask that you appear as a duty attorney for this arraignment.
Sure.
So, Mr. Moore, what that means is that if at any point during this hearing, it looks like Mr. Brown was your attorney on the underlying case. If at any point you have any questions or you want to talk to him about what's going on, he's available here, and I would allow you to do that. Okay.
Okay, thank you.
For the record, this is People versus Chad Moore, file number 216157. Mr. Moore is present here in the courtroom today. and he is here. Mr. Moore, you're here for a show cause hearing for probation. And that alleges that you have not made any payments towards your fines and costs on this case. Do you understand why you're before the court today?
I do, Your Honor.
Okay. And so I'm going to go through a few things with you with regard to your rights. First of all, you do have the right to have a hearing as to whether or not you should be found to be in violation of your probation. You also have the right to have a lawyer present at any subsequent proceedings. If you can't afford one, one would be appointed for you. As I've indicated, Mr. Brown is present here today. If you had any questions. If you are found guilty of violating your probation, it could subject you to the maximum possible penalty on your underlying charge, which is third offense OWI, and that's 5 years. Do you understand that?
Yes, Your Honor.
Okay. Mr. DeLeo, has Ms. Davis indicated how she wants to proceed ultimately with this case? Or does she have any notes for today's hearing?
Well, I think the focus, Your Honor, obviously is getting Mr. Moore to pay. I know he's coming up on his 5-year term of probation. I'm not sure exactly how close he is to his discharge date, but it's getting close. So I think the recommendation would be to, adjourn it out a little bit to at least see if he'll make some efforts to pay, and I think obviously on what he does, ultimately make a recommendation at that time.
Okay. So Mr. Moore, what I would do for today's purposes is enter a not guilty plea on your behalf, and then have you communicate with your agent, Ms. Davis,
Okay.
to see how this could be worked out. But do you want to request a court-appointed attorney to represent you, or did you want to hire your own attorney?
Well, I don't have the money to hire my own attorney. So I would just pay the fines. I'm not trying to be smart.
No, I get it.
In this
I
and that.
I understand. I'm just required to ask you that because of your
Right.
rights. So
Okay.
what I'm going to do, Mr. Brown, is refer Mr. Moore's case to your office for screening for eligibility and appointment of an attorney if he's eligible.
Thank you.
So communicate with Mr. Brown. They have a process where they screen you financially, and
Okay.
he'll appoint an attorney for you if you qualify, and if it sounds like you probably will qualify and did before. So make sure that you stay in touch with Mr.
I
Brown.
definitely will.
Okay. And we'll enter a not guilty plea on your behalf. Mr. DeLeo, is there any objection to a PR bond in this case?
There's not, Your Honor.
So the court's going to set this as a personal recognizance bond, so you don't have to post any money on Mr. Moore, but you do have to continue to comply with all the terms and conditions of your probation, okay?
Correct.
So 2 things. Number 1, you need to communicate with Ms. Davis, with your agent. And then number 2, make sure you stay in touch with Mr. Brown. I'm going to set this for a hearing about 90 days out. If Ms. Davis wants to have that hearing earlier, she can just contact the court and get a hearing date. But we'll set it for 90 days out, and then you'll get notice of the date and time of that hearing, just like you did.
Hopefully by then I can have them paid.
Yeah,
So
I think that would be great for all of us.
Right.
Yeah,
I realize that, Your Honor.
okay. All right, do you have any questions, Mr. Moore?
I do not.
Thank you, that's all for today.
All right, thank you, Your Honor.
People versus Jared Miller, file number 256837. Is Mr. Miller present? Can you come up to the podium, please?
For the record, Chairman, I go back to people. They're wrong, Captain.
Mr. Miller, how did we want to, or I'm sorry, Mr. Brown, how did we want to proceed with Mr. Miller's case?
Your Honor, I have had some difficulty contacting Mr. Miller. He did reach out to me yesterday, Sunday, via text, so I was able to finally connect with him. At this time, I believe we are going to proceed to the trial, which is set later this month. Just for the record, there has been a plea offer in the matter that he could plead to the same charge, different amounts, which would be a misdemeanor if at or before sentencing, he would pay the full restitution. That he is made aware of that, but we are going to proceed notwithstanding.
Okay, Mr. Miller, have you had a chance to talk to Mr. Brown about that plea agreement?
Yeah.
Okay. And you're aware that today would be the last day that you could enter into any type of plea agreement?
Oh, you know, I didn't know that. I just can't see taking a plea for something I didn't do. I mean, I have no problem paying the money back for doing the roof. So I just, I can't make contact with the homeowner to work that out at all. So I just don't know. Here, but I'm not gonna plead guilty to something. I'm not gonna
Okay, so we're going to proceed then with your trial on July 31st. So you need to be here by 8:30 on the morning of trial. I'm going to suggest to you that you should get in touch with your attorney because he's going to be representing you at that trial. And in order to effectively do that, he needs to.
Yeah, my phone went inactive and I won't have it on until after court days. But yeah, so we should be.
Well, this is it's a pretty serious matter. You're being charged with a 5-year felony here. So whatever you need to do to communicate with him. I just want to make sure that you're clear that, you know, any kind of lack of communication or change your mind, nothing's going to stop us from going forward July 31st. So I'm just be prepared to go forward on that day. Mr. Rolla, are the people ready to proceed?
Yes, Judge, in accordance to information, parties have already exchanged pre-trial documentation, witness list, exhibit list, and jury instructions. Copies should have already been provided to the court.
Okay.
Thank you, Judge.
Great. Mr. Brown, any other matters we need to discuss today?
No, Your Honor, thank you.
Okay. So, Mr. Miller, again, we'll see you at 8:30 on the morning of July 31st. Thank you.
Okay, thank you.
People versus Eric Hoover, file number 256840.
For the record, Your Honor, I don't have people. Right on behalf of Mr. Hoover.
The record should reflect Mr. Hoover is present here in the courtroom today. This is the date and time set for sentencing in this matter. Mr. Hoover, have you had a chance to go through the pre-sentence report and talk to Mr. Brown about that?
Yes, Your Honor.
Okay. Mr. Brown, are there any additions, deletions, or corrections to that report?
No, Your Honor.
Are there any challenges to the scoring of the guidelines?
No, Your
Mr. Rolla, do the people have any additions, deletions, or corrections?
Judge, there is one situation on there. I see that actually it's under the recommendation for sentencing. I believe the fee for the drug blood testing is $200, not $250.
200. Okay.
Correct, Judge.
Okay.
But other than that, no other corrections. Thank you.
Do the people have any challenges to the scoring?
No, Your Honor.
Anything on behalf of the people for allocution today?
Yes, Judge. This is the first felony, but the defendant has indicated by his record is a long-time alcoholic. His first drunk driving conviction was back on March 3rd, 1986. This is his sixth drunk driving. His BAC in this case was only a .106 by blood, but that was taken sometime later. In any case, it doesn't really matter. This person's had a long time history of driving while intoxicated, and still apparently is either unable or unwilling to address that situation without placing the public in danger. There's a recommendation in this case of 30 days and 5 days credit. That's mandatory minimum. As a third, I think in light of the circumstances, especially since we're also dealing with a resisting obstruction charge, and as well as a misdemeanor driving license suspended, some jail time support.
I guess I want to ask you one question about your allocution. And maybe I heard wrong. Did you say, because I counted 2 priors. I thought you said 6 priors.
This is Mr. Did I say this? This is Mr. Hoover, is it not?
Yes.
That's what I thought, Judge. 6 drunk driving since 3/3/86. I can go through all of those with the court if you'd like.
I'm looking at the PSI, the adult history in the PSI. 1 of 4 is his first offense in 1989 of operating while under the influence. I have another one in 2006, which is number 2 of 4. And then this one.
But actually, it didn't account for his ones back on 3/3/86 as well as, Judge. It shows up in the lien that we have.
Okay.
System's working a little slow. Genesee County 67th District Court on March 3rd, 1986. Then Flint on March 28th, 1999. OWI 2nd. Then the 71A District Court in Plea on June 1st, 1991. Then we have an impaired in Kalkaska in the 87B District Court on January 10th, 2007, and impaired in the 87B District Court in Kalkaska, 12/15/16. And then the ignition interlock, which was a violation for alcohol as well, Judge, and that's what I.
Okay. Mr. DeLeo, do you know why those wouldn't have been?
I'm looking at the copy of the lien I was provided to do the report, Your Honor. And I can't explain why, but ours does not have those.
Oh.
The rest are convictions.
All right. Okay. Thank you. Mr. Brown, anything on behalf of Mr. Hoover?
Yeah, just one minute. Yeah, Coach.
Yes.
I can't remember if I sent these.
Okay. Mr. Brown, anything on behalf of Mr. Hoover today?
Yes, Your Honor, thank you. I just handed the court some letters from the VA. He is currently in treatment, working with Tricia Myers, who's actually here today to help support him. I guess I am at a little bit of a disadvantage. I was a little confused to hear about the many priors as well, because I'm going off the same PSI that everybody has. And I'm showing and operating under the influence, not just the final charges, but also the charge and arrest. So this wasn't an OWI that was let down. And that was back in 1989, and another OWI in 2006, which were about 18 years apart, I believe, 17, 18 years apart. And other than the instant matter here, his most recent prior was almost 20 years ago.
Well, I mean, obviously, Mr. Hoover was supposed to be operating a vehicle equipped with an interlock device at the time of this offense. So there had to have something had to have happened in the intervening time to bring about that requirement.
Mr. Hoover, again, is currently getting treatment. He is taking psychiatric medication. I know he has some mental health issues that he is dealing with. He currently has a girlfriend, a significant other that he is living with, just recently had a stroke. He is basically caring for her. She's bedridden, 24-hour a day, around-the-clock care. He essentially, at least states to me, that he was sober for many, many years. The stress of being disabled, which he is currently on disability, around-the-clock care for his girlfriend, somebody that he's been with quite a while and truly cares about, and just the stresses of those things. Unfortunately, a lot of times people look to things to deal with those stressors and triggers and things, other than getting perhaps a more or a better kind of help, or beneficial type of help. They turn to alcohol, which is a temporary relief, but it does cause a lot of problems, which Mr. Hoover does know that. This was a very bad decision on his part. I think he understands that. But ask the court to take all that into consideration. The resisting arrest, again, those are things that quite commonly go along with intoxication or being under the influence of something, and we often see those charges together whenever the police are called. He is working on this. It is not something that he wants to define him. Again, he does have a relationship with Ms. Myers in a professional setting. She is here today to support him. So she sees something there that can be salvaged. He is not just an alcoholic. So I would ask the court to take all those things into consideration. I realize that there is a statutory minimum, and I would ask the court to adopt the recommendation.
Thank you. Mr. Hoover, anything you wanted to say today?
Yes, Your Honor. Not really sure where you want me to start. I was introduced to alcohol when I was in the Army. I was at a physical security base. Didn't have anything to do but our job and drink. It's isolated depot, wasn't even a base. And it started from there. I got out, ran into problems. Was trying to take care of those issues. Been trying to take care of those issues. I was sober for, it was going on 18 years. I battled stage 4 cancer without turning to alcohol. I cared for my parents, watched them pass in front of me, didn't turn to alcohol. I was trying to get, I was doing good. I was working with the courts and with everybody to get my license back. I brought it to the court here in front of Judge Hunter. Had the interlocking device put in. Then they changed I only had a couple months ago, and they changed the rule that circuit court couldn't override the ruling of the Secretary of State's office. Had to start all over. Okay. I dealt with that. Then my parents passed. My girlfriend had a stroke. She's bedridden. Dealing with that, and at the same time, I was going through my cancer, so I had to take care of myself and her at the same time. And I was still sober after. And then just the last year or so, they I don't know. I didn't even know I have what I have, what they say. But I was working with the VA and going through the things that I've been going through. I like to think that I was getting better in my thinking, in my stresses, and it just, I don't know what happened. You know, they put me on these medications and they were up, couldn't find the right, they were just trying to adjust my medication, trying to get it right. I felt like I had to go, had to leave, had to get out of that house. And so I did. The only way I could do that was take that vehicle, because the one with the interlocking device was down. And I was on the side of the road. Wasn't even driving. Well, it's really cold. Car was running. I did what I did. I know it was a mistake. I know with the key being in the ignition, it didn't matter. I don't know, maybe it was a cry for help. I don't know, but it was. And here I am today. And I regret doing what I did. Didn't want to hurt anybody. Didn't want to hurt anybody. All I knew is that when they came in the back door, I thought I was being attacked. I didn't hear anybody say they were. I just reacted. That's pretty much all I got to say, Your Honor.
All right, thank you. Mr. Hoover, I did read through the pre-sentence report in this case, so I'm familiar with the circumstances here and your actions in operating a vehicle that you weren't supposed to be operating while you were under the influence. The experience you had with police officers who were responding to a call. Somebody had called this in because they saw you on the side of the road urinating. And
I don't know if I can say anything about that.
you can say that's not what happened.
Say that may be what they may have saw or think they saw, but that's not what happened. No, I had a change of clothes in the vehicle, and I had urinated on myself while I was in the vehicle. I had gotten out of the vehicle to change my clothes.
Okay.
You know, I was not urinating on the side of the road, especially on M32. For heaven's
So
sake.
somebody saw something that didn't make sense to them and they called the police about it. That's how the police got there. And you operated that vehicle to that point, right?
Yes,
Okay. So whether you were on the side of the road or not, you drove that vehicle under the influence of alcohol to get it to where you were on the side of the road, right?
well, that's where I started drinking the alcohol, was when I was on the side of the road. But yes,
Okay. So you drove to that point.
yes,
You had urinated in your pants, so you
Yes.
pulled over.
yes.
And that's when you decided to start drinking.
Well, yes,
Does that sound believable to you?
well. No,
If you're-
Your Honor,
if you're in my
I
position-
suppose it doesn't, Your Honor. No, I suppose it doesn't. It sounds reasonable, but
So it sounds to me like, you know, whatever you're doing in terms of treatment, which is good,
oh,
I'm sure it's got to involve like having some accountability and being
Oh,
honest
absolutely,
about
Your
what you
Honor.
did. And you're standing up here in front of me today, acting like, you know, you're just this guy on the side of the road who made a
No.
mistake and drank, and the police just showed up.
I understand.
So,
Your Honor.
I mean.
No, it's, yes, I understand. Yeah, I was there. I did it. Yes, Your Honor.
So, yeah, I mean, you gotta, if you're really serious
I'm
about,
totally-
your treatment going forward, you need to start being accountable
Absolutely.
for your own actions and not pretend like it wasn't what it was. So,
Yes,
especially at this point, because it's not gonna do you any good.
it's,
I'm looking at it,
it's,
I'm a rational person and I can see when somebody's making something up or trying to act like it didn't happen the way it did.
no, it's.
Let's just be straightforward as we go
Absolutely.
forward here, because you're gonna be on probation here. I'm gonna give you the opportunity to be on probation and to avoid significant jail time
Yes, sir.
because of the types of things that you have done since this, to get a hold of the problem. But if you're gonna be successful on probation, it's gonna be because you're being straightforward about what you're doing, both with people who are trying to help you, who are here in the courtroom.
Yes.
And
I'm pretty
with-
much upfront. I'm,
Okay, I'm gonna talk now. And with your probation agent, otherwise we're gonna be back here and it's not gonna be a good result for you because you're at the point now where you've got a potential prison time. And I know that's not what you want to happen, and it's not what I want to have happen either. But in order to avoid that, you're gonna have to comply with the probation. You're gonna have to be straightforward with the people who are trying to help you and with your probation agent. Looking at things as a whole, I do think the recommendation is appropriate. I'm gonna follow that recommendation generally. I am gonna hold some jail time over your head in advance. I'm gonna explain that in a second. So as to count one, which is operating while intoxicated, the court's gonna sentence you to probation for a period of 2 years. I'm gonna adopt as the conditions of that probation, all the terms and conditions listed in this report. The court is going to order that you serve 30 days in the Otsego County Jail up front. The court's gonna order 6 months total, the first 30 days up front. I'm gonna hold the remaining 5 months in abeyance to be used at the discretion of the court. So if you comply with your probation, if you do the kind of things that you need to do going forward, you'll never have to serve that additional 5 months. If you do violate your probation, though, the court can impose any or all of that jail time immediately. So that's a significant consequence, and I hope an additional motivation for you to comply with your probation. The court is going to order a crime victims assessment of $130, court costs of $325, attorney fees of $350, $500 fine, OUIL reimbursement testing fee of $200, a DNA testing fee of $60, $68 state cost, and a supervision fee while you're on probation of $30 per month. As to the resisting or obstructing charge, again, 6 months, 30 days up front, credit for 5 days served. The remaining time held in abeyance. Probation of 2 years, subject to all the terms and conditions listed in the report. As to the operating while in violation of license restriction, $50 state costs. On that charge as well, 30 days in the Otsego County Jail with credit for 5 days served. No time held in advance on that one. All those sentences to be served concurrent to each other. You do have the ability to seek an appeal of this sentence. We're going to provide you with some papers that explain to you what your appellate rights are, as well as how to request a court-appointed attorney to help you with the appeal.
Judge, I'm sorry, I may have missed it. Did you do the $68 state cost on count 2?
No, but we need to put that.
Okay.
Yeah.
Your Honor, he has acknowledged receipt of his appellate rights on tendering it to the court.
Thank you. You are remanded to the custody of the county at this time. Good luck to you going forward, Mr.
Mr. Fuller? Oh, sorry. Yeah, I gave you a little note.
Your Honor, I think that's my morning.
Yes, thank you. That concludes the court's morning docket. The court will be in recess until 1:30.